Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Robert E. Temmerman, Jr. I'm just going to call him Bob. And Bob is an attorney who is a managing partner and founder of a law firm called Temmerman, Silly and Coleman, LLP in San Jose. He specializes in estate planning, incapacity planning, and estate and trust administration, and his firm also is involved in estate litigation services. Bob received a BA in economics and political science, magna cum laude from Boston College in 1975, and he received his Juris Doctor degree, or his law degree, from Santa Clara University, also magna cum laude, in 1980. He's an active speaker in the estate planning community, not just here locally, across the country, including the Jerry Kasner Estate Planning Symposium, which is presented by Santa Clara University. And he's also spoken for estate planning councils and bar associations, and he has contributed to books including California Estate Planning, which is published by Continuing Education of the Bar. And Bob also participated in writing our local rules of the court for Santa Clara County Probate Court. On a personal note, Bob is quite an athlete. He tells me in 2012 he had a bike trip across the Pyrenees in France and Spain, which is pretty cool. He heliskis every year, and he plays amateur adult hockey, and he tells me his team is headed for the finals again this year. So congratulations, Bob, and thanks for joining us again.
I'm sure I had nothing to do with the team heading to the finals.
Well, you're there. You're taking your space. Okay. Today, Bob and I are going to talk about the situation. I'm a trustee, now what? And with old Benjamin Franklin used to say, nothing's certain but death and taxes, and unfortunately, sometime during your life, you may be named as a trustee, or it may be even good for you to be aware of what are the duties of a trustee when you're writing your own trust, to understand what you're asking your friend to do if they take that spot, or your family member. So anyway, so we thought it would be helpful to get some basic information to you. Now, this is a very technical area. Bob went to the university for many years, and he's got many years of experience under his belt, as I said, in this area, and we can't share it all in a very short interview. We're only going to be able to hit some highlights. So this is just an introduction, and we want to encourage you to carry on this conversation with your own attorney. Bob and I are both California practitioners. He's a California attorney, I'm a California CPA. So each state has their own flavors as far as, and even their own, each community. We said we have a rules court of Santa Clara County, there's rules of court in San Francisco, San Mateo, and so forth. So there's some variation that happens from place to place. But again, we're going to hit some highlights here of things to be aware of, and again, to be the, hopefully, an incentive for an additional conversation. All right, Bob. There are some people that think, and they really do, I know that you know too, that since they made a living trust, nothing needs to be done. If somebody passed away, don't worry, no big deal. So what do you have to say about that?
That's probably the single most common misconception among individuals who are either plan their estate plan, or it's been represented to them that it's so easy that really you don't need to worry about it. But in fact, if the creator of a trust passes on, and that creator is technically called a settlor of the trust, the one who sets it up, when he or she passes away, the successor trustee, the person in charge of that trust, in fact does have many duties and responsibilities to the beneficiaries of the trust. They have to collect the assets, they have to pay the decedent's debts, and they have to ultimately distribute the trust assets to the beneficiaries in accordance with the terms of that trust. So to say that there's nothing to do is really not doing anyone a service. There's actually quite a bit to do. However, it is true that it's because most trusts are not court supervised, it is much more expeditious, cost effective, and indeed simpler to administer a trust than it would be a corresponding probate estate under a will.
Right. So there may be some change that's happening here. So we have a history for husband and wife situations of bypass trusts being set up. In other words, if, let's say, husband passed away, then let's just say traditionally his assets may have actually been set aside in a bypass trust, in a separate trust. We actually had to divide the assets in that case. We may be seeing a little bit less of that in the future. Maybe you care to comment about that for a moment.
The question that you're asking me is really a tax question, Mike, and it goes to when an estate plan is designed between a married couple, whether a same-sex married couple, opposite-sex married couple. If they are married, what sort of planning did we traditionally do for those clients? And up until the last few years, our what we would call estate tax exemptions were as low as $1 million, and actually before 2001 as low as $675,000. So if you died with an estate in excess of these exemption amounts, the typical plan would be to create from the decedent's assets a bypass trust so that they would not be taxed a second time. They were exempt from tax at the first death, they'd be exempt at the second death. With the recent change in the law effective this year, we now have some permanency in the estate tax arena, and our estate tax exemption is $5.25 million. So most clients are never going to reach those thresholds. More importantly, Congress saw fit to adopt and make permanent portability. And portability allows us to combine the exemptions of both a husband and a wife so that no tax at the first death, I can add the predeceased spouse's exemption to the surviving spouse's exemption and effectively shelter $10.5 million. Yes, I've got to file a federal estate tax return at the first death, but bottom line is the planning has gotten simpler. We don't necessarily need to create bypass trusts. There are other reasons that we might want to, management and control reasons, but from a tax point of view, we can get some of the same, not identical, but some of the same tax benefits that we could get in traditional bypass trust planning.
Right. So the real incentive, basic incentive for bypass trust initially was to be sure that you didn't lose the exemption of the deceased spouse. And now that's not as much of a concern. Again, we've got much larger exemption. So that gives us more flexibility. We've had other programs about this that you may look up about portability and so forth in past episodes of the show. But I just want to point out that it's sort of changing this administration area too, because I had a client that frankly he was in shock when I told him, oh yeah, now we're going to have to separate these assets, and suddenly we've got another tax return that we've got to file, and you need to be very careful about how you handle these assets and so forth. I mean, it's like, oh my gosh, I had no idea what I was doing when I set up this trust.
Unfortunately, clients should be educated during the planning process.
Yeah.
Maybe not on all the details of what's involved, but in fact that there will be some administration involved at the first death. And whether that's the creation of a subtrust, such as a bypass trust or a marital trust,
right,
or not. Sometimes it could be a trust, a special needs trust for a child that's created. But bottom line is that's client education. Educate the client as to what can reasonably be expected.
Right. Oh, and what it means too, folks, is that you may want to revisit your estate plans. So we'll be having additional programs about this as well. And it's not really the focus of this, but again, it's just a thought. It may be a good idea to see your attorney in the not too distant future to see if maybe you can make things a little easier for your family.
Mike, just as a follow-up to that comment, We've tried to get many of our existing clients back into the office to simplify their plan because they no longer need the complexity that they needed as few as just 3 or 4 years ago. And most clients are opting into a simplified plan. So if you can make life simpler for the surviving spouse and family, there's no reason not to do it.
Yeah, that's great. Okay, so we just maybe saved you a lot of money and trouble. Okay. Now, a decedent had a living trust. Does that mean that no probate is required?
Let me just clarify for your viewers. Probate is the court-supervised process of administering the decedent's will, or if they died without a will, the decedent's assets. When you created a trust, you're designed to avoid probate, but you're only going to avoid probate on the assets that are inside that particular entity. And it's not uncommon that individuals will oftentimes forget or fail to put assets in the trust. So although our courts are very receptive to asking them for a court order post-death to add those assets to the trust without going through a formal probate process, not all of our jurisdictions are willing to do that. They require proof of the decedent's intent that indeed he or she wanted those assets to be part of the trust. And if they're not titled in the trust name, some courts may indeed require that administration, a probate administration, take place concurrently with the trust administration, but only for the assets that are not in the trust.
Okay. Is it unusual for families to neglect the formalities of administering trusts after a death, and are there any consequences if they don't?
Well, you probably can answer this question better than I can. Yeah, there are consequences. And although you might have access to assets because you're the surviving partner or spouse, failing to actually administer the trust according to its terms can make the trust stale. Many years can pass by and you found out, oh, I was supposed to be filing tax returns. I was supposed to be doing accountings for a particular trust, and I wasn't doing them. And so it can create a fair amount of anguish when the realization finally hits home that, oh my gosh, I have to go back and now file 5 years or 10 years of tax returns. And we've done that. We've had to advise clients that, yes, we need to respect this. Failure to do so will cost you a small fortune down the road.
Okay. What is community property, and why is that status important for trust administration?
Well, community property is defined in our family code as property that is owned between a husband and a wife, or between a married couple, if they're same sex, that is acquired during the course of the marriage, generally as a result of one's time, labor, effort, skill. That would be your W-2 compensation, your compensation from any work in a business, such as a partnership or a corporation. At any rate, that is presumed to be community property when it's acquired during marriage. By contrast, separate property is property that you owned before a marriage, or property that you might have acquired by either inheritance or by gift during the course of a marriage. And the reason that characterization, that's what we call it, what's the character of the property, is it community or is it separate, is important is because a decedent can only dispose of his or her half interest in the community and all of his or her separate. So trying to identify what is community and what is separate is key for purposes of, well, what will the trust operate on? Will it operate on all of the property? Will it operate on the decedent's half interest in the community? And how is that to be disposed of under the trust terms? So characterizing assets is one of our first objectives, identifying assets and then characterizing them. For a single individual, community property or separate property, it's irrelevant, doesn't matter.
Right. Are there significant legal fees for administering a trust? And does having a living trust really save legal or other administrative costs? You know,
I can only answer this generally because there are exceptions to every rule. My experience has been that generally the legal cost of a trust administration is about a fifth to maybe as much as a third of the cost of a full-blown court-supervised probate administration. However, having said that as a general observation, there are exceptions. We have some trust administrations that involve litigation, that involve significant tax issues, that involve the liquidation and sale of businesses, where the cost of administration can approach that of what it might be in a probate. What you gain from a trust administration, however, is privacy that you don't have in a probate administration. More importantly, you gain expediency in the administration process because you don't have to set matters for court hearings. So on average, most clients we advise can expect to save roughly 2/3 of what it otherwise would have cost, and sometimes more. The simpler the administration, the simpler the design, the more expeditious and cost-effective the administration.
Okay. How much cash should you keep on hand for incidental items at death? So this doesn't relate just related to a trust, but there again, there's some people maybe that don't have a probate. But meanwhile, I mean, there are things that happen after death that probably should keep some funds on hand for.
Let me try and answer that in two different ways. If you are a successor trustee, which this particular program is about,
Right.
it doesn't take long to be able to access the decedent's bank accounts. A certification by trustee can be drafted, signed, notarized, and delivered to the financial institution, and generally within 24 hours you should have access to the decedent's trust assets.
Okay.
Now, having said that, it's not uncommon that clients will keep a fair amount of assets not in the trust. That might be in a joint tenancy bank account between a husband and wife as opposed to a trust bank account. And those assets that are in joint tenancy are immediately accessible by a surviving spouse. Likewise, if you're not married but you're a single individual and you are the successor trustee of that individual's trust, if you're not going to access the trust assets quickly, it would be helpful that if the decedent did have some assets in his or her name, we can access those in most cases by what's called a simple affidavit procedure, but we have to wait 40 days after death in order to access those assets. And more importantly, there's statutory limits. It's currently $150,000 or less that can be accessed of the total assets that otherwise would go through probate.
Mm-hmm.
But having a little bit of cash on hand at the time of death will only make it easier on the surviving spouse, the successor trustee, whoever it might be.
Right. And we did another show on probate, but I'll mention it also here, that I had an experience actually related to handling my father's estate and trust. And I was surprised to learn that he had his Social Security payment for the month that he passed away that had to be paid immediately back to Social Security. And I believe that they just took the money back out of the account. So anyway, that's something that you really need to be aware of, that you need to watch your bank account because maybe there's not as much in there as you thought.
If you're the insured participant and you're receiving Social Security benefits, you're correct. The Social Security Administration will automatically back out that last payment with one exception. If you died on the last day of the month, then you're considered to have survived the whole month and they will not back it out. But most of those last payments will be backed out and reversed once the Social Security Administration has been notified. And typically it's the mortuary who notifies Social Security for you.
Right. What's the significance of a death certificate?
The death certificate, like a birth certificate, is an official paper by the county and state of residence in the state of California that certifies that this particular individual with this Social Security number and this address is in fact deceased. And that death certificate will be needed in order to collect a number of different types of assets that belong to the decedent. If the decedent had some non-probate assets such as joint tenancy, in order to clear title to real estate title that way, you'll need a death certificate. If they had community property titled as husband and wife as community property, you will need a death certificate to clear title to that real estate. Oftentimes, a certification of trust is one document that a financial institution will require from the successor trustee, along with a certified copy of the death certificate. So they know, in fact, the settlor, who is oftentimes the initial trustee, is no longer alive, and now it's the successor trustee who's taking over. So one of the keys are early on in the taking on the role of a trustee is just to make sure that you have an adequate number of death certificates. We can always order more, it takes a few days, but try and determine how many different financial institutions you may have to work with in order to order an appropriate number of death certificates.
Right. Okay. You're nominated as a trustee. Do you have to accept? And what are some things to think about before you accept?
The simple answer is no, you do not have to serve as a trustee. And in fact, we do a fair amount of counseling, Mike, of our clients, that before you say yes, you need to kind of know what you're getting yourself into. It is a job, and it is a fairly time-consuming job for an individual to basically collect all of the decedent's assets, account for all of those assets, pay all of their bills, file all of their tax returns, including tax returns that might have been non-filed for prior years, and ultimately distribute the assets. It is generally a job that is not terribly appreciated by the beneficiaries. It is a job that oftentimes has litigation exposure. I sometimes tell my clients, being a trustee is nothing more than wearing a big bullseye across your chest and saying, come and get me, because you are the target when a beneficiary feels that he or she has been improperly served by the trustee.
Okay. Maybe you can tell us for just a few minutes, what are some of the notice requirements that apply for trusts?
Trusts, unlike probate, one of the first notices that go out required by our statutes in California is basically a notice to heirs and beneficiaries that there's been a change in the trustee of an irrevocable trust. Oftentimes that's as a result of the death, but it could be because of an incapacity where a trust becomes irrevocable. That notice has to go out, and it alerts the beneficiaries of the trust as well as heirs that they have 120 days from the date that they are served with this notice to challenge the validity of the decedent's trust. So it starts a statute of limitations period to say, we want these administrations to be over. So you've got 120 days to figure out, is this trust that belonged to the decedent valid? And if it's not, you have 120 days to challenge it. So it's a notice first to heirs and beneficiaries of the trust. In addition, trustees by statute have to give notice in certain circumstances to the California Department of Health Services, to the Victims' Compensation Board, and sometimes to the IRS with respect to a notice of fiduciary relationship. So there are a number of notices that might have to go out. There is no mandatory notice to the deceased settlor's creditors. It's an optional notice provision that we can opt into, and sometimes we do in appropriate circumstances, but more commonly we don't. And when you don't opt into this shortened statute of limitations period, you have 1 year. So creditors basically, unless they got a notice otherwise, have basically a year to file a claim against the decedent's trust.
Okay. So Bob, we've been going to some of these conferences and the stuff. I'm thinking of this notice area, and so they're promoting the idea of maybe setting up a trust in another area, another state, let's say Delaware. Can you bypass notice requirements in California by setting up a trust in another state?
Certainly, almost all jurisdictions look to the intent of the settlor. And yes, indeed, a California resident can create a trust in the state of Delaware or Nevada or some of the other creditor protection-friendly jurisdictions. Closest to us would be Alaska, Nevada, South Dakota.
Okay.
But Delaware also is a very favorable jurisdiction. And if certain requirements are met, a settlor can create a trust to protect their assets, those trust assets, from their creditors. So it is possible in some jurisdictions to avoid some notice and to protect those assets.
And
California is not one of those jurisdictions.
I know that
however.
California isn't, and so I think part of the thing too was as far as what information has to be provided to beneficiaries. And
there are some jurisdictions that don't require notice to
Yeah.
beneficiaries, Delaware being one of them in certain circumstances. I'm not familiar with
Yeah.
the specifics of each
Yeah.
of the various jurisdictions,
Yeah.
but if you're interested in further privacy and you're interested in creditor protection, we typically would associate either Nevada or Delaware Council or South Dakota Council.
Okay. We only have about a minute left, Bob. Maybe you can throw out some final wisdom to sort of wrap up this little discussion we're
Sure.
having.
I'd be happy to, Mike. Trusts have been commonplace will substitutes for 30, 40 years in California. They, more often than not, more people have trusts than don't. And they indeed serve a very useful function. They expedite the administration. They make it simpler on the surviving family members. But it's key, if you are a trustee, that you don't take on that job lightly. It is a time-consuming job. It's a job that you will probably be inadequately compensated for. We always tell our clients who are trustees, keep track of your time, because although you might want to waive your right to compensation right now, come talk to me in 6 months when the job is almost over and see if you still want to waive your compensation.
Mm-hmm.
Bottom line is, a good advisor, accountant, financial advisor, attorney will be most helpful and more often than not will be very beneficial, not just to you as the trustee, but also to the beneficiaries of the trust. So seek that advice shortly after a settlor's death.
Bob, thanks for joining me.
Mike, my pleasure.
Folks, we're all out of time. Hope we've given you some things to think about, and we'll see you next time on Financial Insider Weekly.